Back up to give you the clear overview. I know that your honors have read the record. My clients were invasive cardiovascular surgeons. One does the stents, one does the pacemakers. They were recruited to this area from Chicago. They were brought down by the hospital with a recruitment agreement. And because the hospital cannot directly perform that action, it's ordinary practice for them to place them and support them in a local practice. That's how they connected with Florida Cardiovascular and worked at Florida Cardiovascular. Over the course of their time there, it's clear, and the judge found that they were not paid the salary that they were promised. That's not in dispute. At the end of 2007, Mr. Mkhitaryan, who was the CEO of the hospital, testified by deposition at trial, and we had his actual calendar records showing that he met with both of these parties separately and together to try to bring them together and have some kind of an orderly transition or resolution to their practice difficulties and differences. Then we have the testimony at trial from the CFO of the hospital, who said he was directed by Mr. Mkhitaryan at the end of November or the beginning of December to start writing up an employment contract for these two physicians, my clients, starting January 1st, 2008. So at that point, the hospital, who has somewhat of an interest in this but is not one of the parties, is sensing that the parties are going to split apart and they want a fallback position. They want to employ my clients at the hospital. Then we have the testimony of Florida Cardiovascular's very own office manager, Patty Reisinger, who said that on December 8th, she got a phone call from someone at the hospital telling her that on January 1st, my clients, the Rows, were going to be employed at the hospital and asking for her assistance as the office manager of Florida Cardiovascular to help in the transition and moving patient files and things like that. And she said yes, she would help with that. Then we have Dr. Matthews, who at the time was an employee and was becoming one of the partners of Florida Cardiovascular. He testified that he was told by Dr. Modi that the Rows were no longer going to be at Florida Cardiovascular come January 1st, 2008, and Dr. Matthews doesn't put the Rows on Florida Cardiovascular's call schedule from January 1st, 2008. So if there's no meeting of the minds, and these parties up until the end of December of 2007 have no idea whether the Rows are going to be there or not, why isn't Florida Cardiovascular making a call schedule and including them on it? Why, as Judge Berger pointed out, why is Florida Cardiovascular changing its locks and locking my clients out so that they can't go in and get their personal products, personal property out of the offices? Because Florida Cardiovascular knew very well from its conversations with the hospital, from everyone involved, that my clients were going to start work at the hospital as employees on January 1st, 2008. Then we come to Dr. Modi himself, who was at that time the sole owner of Florida Cardiovascular. He testified, as Judge Berger pointed out, in his pre-trial deposition. He was asked by my co-counsel, Mr. Levenstein, was this agreed? Was this a mutual termination that was going to happen on December 31st? He said, which doesn't help anyone because it's not verbally recorded. So Mr. Levenstein says, yes, which appears in the record, yes, question mark. Dr. Modi says, yes. At trial, he recants his testimony and he tries to double back from that when I challenged him on it, and he says, no, this wasn't mutual. I didn't really mean yes. I was just answering yes. I was parroting yes. Mr. Levenstein asked me and I mumbled something, and then he says yes, and I just said yes. I randomly just parrot answers back to people and say yes. Clearly, when you read the record and you see the transcript, and it goes on for about 10 pages in the trial transcript, Dr. Modi testified pre-trial that this was agreed, this was mutual. Everyone, including the hospital, knew that the Rows were going to leave as of January 1st, 2008. And then, because that wouldn't help their position at trial, Florida Cardiovascular then changes it and says, no, we had no idea, they should be penalized. And the money that we got, Florida Cardiovascular got from the hospital under the recruitment agreement to pay these physicians their salary, that Florida Cardiovascular kept because the judge found very clearly that they didn't pay the full salary. So that means it wound up in someone's pockets, and it's not in the hospital, and it's not in the Rows, so it's in Florida Cardiovascular's hands. Florida Cardiovascular should be allowed to keep that excess and be enriched by that amount and shouldn't have to pay it to anybody simply because they want to say they didn't know even though the evidence overwhelmingly is to the contrary.